Chapter 26, Part 3. Okay, so we're talking about ownership of real property, and transference of the ownership of the real property requires a deed, and the deed has to be recorded in the Superior Court Clerk's office in the county where the property lies. The traditional way that this is done is through a book called a deed book, and there are many of them in each courthouse, and they're usually numbered by letters. And then there are what are called grantee and grantor indexes. The grantor index lists every time a person transfers property, they're called the grantor, and the grantor index lists in alphabetical order by the grantor, and then says who the grantee is, and then says where the deed can be found and what type of deed it is. The grantee is the reverse effect. The grantee is where the grantee is listed by alphabetical order and who they got it from. So when a lawyer or anyone else does what's called a title search, they look through these deed books to find every transfer that's been made and recorded, usually for the last 60 years. They go through the grantor index, and then they go backwards to the grantee index. And so what they're looking for is any transfers that may indicate that the person who currently claims to own the property doesn't actually own the property, or for mortgages that are also recorded that have not been satisfied of record. So the recording of the deed or any interest in real property basically puts the public on notice of the new owner's interest in the land. And that's how you, what we call, search a title. And then the attorney will review that search and issue an opinion as to who the owner is currently of the property and what encumbrances there may be on the land. We are currently in the process of making all that data online, so that eventually you'll be able to hopefully search titles everywhere in Georgia online. Currently, I think you can do that in some places. I'm not sure how complete that is. Okay, so it also prevents the previous owner from fraudulently conveying the same interest to another buyer. Okay, let me point out that Georgia and most states, the first to record is the legal owner, not the first to get the deed. So if A sells his property to B on day 1, and then on day 2 A sells the property to C, and C records before B does, C is the rightful owner. Okay, because C was not on notice that the property had already been sold. Of course, there may be some fraud involved against A for selling the property, but the rightful owner under the law is the person who records first. Okay, another issue in real property is what's called adverse possession. You've probably heard of this before. It's sort of like squatter's rights, so to speak. This occurs when a person possesses the property of another for a certain statutory period of time, and that person automatically acquires title to the land just as if there had been a conveyance by deed. The requirements are that the possession has to be actual and exclusive. The possession has to be open, visible, and notorious. In other words, you can't be hiding inside the property. It has to be visible so the public knows, and particularly the rightful owner. It has to be continuous. You can't leave for a period of time and come back and claim adverse possession. And it has to be peaceful. It has to be hostile and adverse. So what's the difference between peaceful? Means that you're there without causing somebody not to take possession by threat or force, but it also has to be hostile in the sense that you're not doing it with the person's permission who owns the property. It has to be adverse. Okay, so how does this come about? Sometimes I want to show you a case that I actually had. I'm going to have to get the whiteboard for this. Of quickly, let me show you the whiteboard. Hopefully you can see this. And you see A and B, these represent two tracts of land. You see a black line in the middle. A being the current owner of that section of land, B being the current owner of the section of land on the right side. And then you might see, hopefully, a little line, cut line, made of red that goes over into A's section of property. Okay, I'm going to put this back, but keep in mind what I just talked about. So this was a case I actually got involved in. And A's predecessor in land, when that predecessor owned the land, B put up a fence where the red marks are, which was encroaching on the land now owned by A. Years later, A bought the land, and when A had the land surveyed, she found out about this encroachment with the fence, and she sued B to either have the fence removed or be paid for the fence. The judge in the case ruled that B actually acquired the land by adverse possession because that fence had been there for more than 20 years, the Georgia requirement for adverse possession, and had met all these requirements. Both parties had proceeded pro se without attorneys, and so the judge called me after he issued his order and asked me to draft the order and to draft the other necessary documents to evidence the change in the property. I bring this up because it's a good example of adverse possession, but also because I like to illustrate how Americans are protective of their property interests, because after the judge ordered this, sometime later, A actually shot B. These were two old ladies. A ended up in jail. B was all right, survived. But anyway, always think that's an interesting story. Okay. So that's adverse possession. The purpose of the doctrine is to include society's interest in resolving boundary disputes and in determining when title to property is in question. It also punishes owners who don't act within a reasonable time against the adverse possessors, and awards people for possessing land and using it for productive uses. So back in the 1800s, that was probably much more of a rationale for adverse possession. Okay, we're going to stop there and pick back up with part 4 of chapter 26.